has refused to engage in discussions about that and the consequences for his children. And it's really that level of engagement that the social workers seek, which is material to them.
Do you know what Mr. Nixon is talking about, this assessment of violence growth?
Well, I think that assessment is within this court bundle, and I believe it's in the F section.
Not right, Mr. Nixon, you've got it already?
Yes, it's right in front of me. It's F58.
Yes. Well, can't this court decide whether your client is being appropriately protected of his own children or not on the material like that? It being a fact, apparently, was a finding as set out in paragraph 7. Seems to be really a debate about his attitude.
Well, yes.
Yes.
Yes, I've forgive me. I've looked
If
at.
you find a judge insisting against the protester, any party, but the case must go on even though that party instinctively feels it's not ready. That's a horse story to start, but if there comes a point when I agree with you, justice can't be done. Stop. We'll stop. But my information is, I'm not hearing anything at the moment which precludes me from starting with it.
The concern my client has got is that the finding is predicated. Well, one of the issue is we can't work with them because you can't face these issues. My client's position is I've never seen anything in black and white that really tells me the standard in fact. If there was something, and one would suspect there could be a police investigation related to that is standard in fact, my client would have an opportunity to reflect. The concern is that there could be a finding that he is failing to reflect because it could be seen that he is, on the basis that there is not something for which you can, excuse my terminology, but have faith that it's accurate.
And there is a fact. Uncle Carl failed to protect his family at risk of potential emotional harm by allowing him to expose violence. Uncle Carl was found to be culpable. And there's the finding.
This is going to be perhaps a very loose and discreet point. The limitation is an agreed threshold. It is a world apart from one where findings actually, well, evidence is tested.
Well, because
if a parent
somebody agrees something happened, it happened.
but no, forgive me, Your Honour. It is an agreement that a risk has arisen as a result of something happening. I'm looking at F28. F28 is what Carl is really saying about Mark.
What's F28?
This is a threshold. In the previous proceedings, we're referring to his findings having been made.
You're saying paragraph 7 is a misrepresentation of what was agreed as fact in those proceedings.
Found. I'm taking issue with the word found. If one is glad no other plans that they're amenable to, then my invitation is, if anybody agrees with threshold, it is not necessarily something
And
that
if
the court
Uncle
finds.
Carl agreed in proceedings relating to his own children, that which is set out in paragraph 7, that is a finding. It was a finding which informed the outcome in those proceedings.
My
The
invitation,
judge was absolved from the responsibility of discovering the facts because the parent to be found. Any other points, Mr. Wilson?
the interim position, very mindful of this, the interim position. If the girl's plan is for unsupervised, why do you need to wait? Obviously, I've had that raised as an issue. The plan is for unsupervised, local authorities are using
we won't be waiting if get my way, get the hearing up and running and read the topic.
But again, I appreciate we'll be waiting, but again, we've got 2 weeks between now and then, and if the plan is for unsupervised in any event, my invitation is if the least interventionist, and we are still within the court proceedings and it's an interim, what is the jurisdiction for saying that supervision is the least interventionist when the plan is for unsupervised?
Is this controversial with any other party?
Yes, potentially. It's not something I discussed.
No, I'll definitely resolve this issue resolution. I think it's the point of view. Anything else, Mr. James?
Just the application to withdraw, I think that's the only thing left on my list.
Withdraw.
Yes, the application, the C2 application, but right at the start, does the local authority need permission to withdraw it? I would simply, yes, I don't care. I would simply
I
say,
don't have ever seen an application by an authority to change its cap. There are far too many changes because planning seems to be very difficult in some cases. But
why? It would
the cap one there has to be the board properly to scrutinise it. So if it changes, it changes.
My invitation is withdrawing the terminology. I would invite that withdrawing is approach. If it wanted to change its name to first care plan, the first final care plan, and the final care plan.
I mean, the fact
so long
that
as it's in the
Thompson
budget.
changes its plans may be illuminating of the merits of the final plan. But I can't stop the local authority telling the court and telling you, as they must, that their plans have changed.
No, absolutely.
I don't think it needs an application to introduce.
It was the withdrawal I had concern with. I still want the 1 of January in the one.
Of course,
Yeah.
every care plan should be fine. No problem with that.
Absolutely not, Your Honour.
One final thing I raised, just because it may become an issue, so that you're aware of it.
Yeah.
Jade, surname forgives me,
Lamb.
Jade Lamb, social worker, led to, telephone conversation led to these powers of protection with the sex. This is the statement, just given the statement taken. The content of that is disputed. I have it on firm instructions that a tape recording of that conversation was made. It was made with Ms. Lamb's knowledge, and it goes to the very issue of harassment.
So it's a telephone call between.
Sorry. There is a telephone call between Ms. Lamb and Dad.
Right.
That is contained
It's
in
not a social issue.
social worker and Dad. That finds its way recorded in Ms. Lamb's original statement, this statement. That takes issue with that, disputes that he threatened to kill her. There is actually a telephone
Somebody was tape recording the conversation,
with both parties' knowledge.
right?
That's going to make reference to what was actually stated in his statement. I simply raise now, for the purposes of admissibility, whether or not the court would like copies of that recording in the interest of having a
There's
full
a dispute between two parties to a conversation on telephone as to what was said in that conversation. It's a agreed fact that a tape recording of it. That must be one of the rare circumstances in which I'm prepared to listen to a tape recording. Is that right, Mr. Brown? There's a tape recording on it?
I have previous knowledge of that. I think the social worker's position is that they had been told by Mr. Howson on occasion that he taped everything, so they're not being taken by surprise at the proposition that this particular conversation was taped. What I'm not conceding at this stage is that there was a prior agreement by the social worker to this particular conversation being taped. However, if there is a recording of it, then clearly that is the best evidence of what was said within that conversation.
Does anybody object to Mr. Nixon introducing in farmer's evidence the tape recording of the telephone call?
He's entitled to produce as part of his evidence whatever he produces as an exhibit to it.
It might assist in the interest of brevity
Well,
mind.
it's part of your case, right? It is your client who is doing the taping. Yes, but if he wants to support his case by contemporaneous record, which is what the tape recording is, but what was said, by all means.
Those instructing me have done a transcript already. I've circulated a transcript for release, and if anybody wants to listen to the tape, it might be easy to get that.
Right.
obviously my solicitor.
that they spare me the task of listening to it, if the transcript is prepared, and all the applicants can listen to it and check it against the transcript.
Might send them back very briefly.
Yeah.
Unsupervised, please disclosure, transcripts, private law. How long did? Are you sure we're forgetting the private law? No private law. You sure? You sure?
Your Honour, on behalf of the Children's Guardian, myself and the Children's Solicitor prepared a position statement. I hope you've had the
Yes.
opportunity to consider that.
Yes, I
I'm
have.
sorry it's rather lengthy. The reason particularly for that was that I wanted the court to be aware that Ms Linden wrote to the court on the 2nd of February, really out of a sense of growing frustration as to the way in which the local authority appeared to be formulating their plans for these children. Because what effectively happened was the original care plans were filed, which effectively recommended that the children would remain living with their mother, not obviously in Mr. Howson's home, but would remain living with their mother, as we've already heard, with no public law framework around that, and supervised contact, supervised by the mother. On the back of that care plan, quite properly, given that we have two girls aged 14 and 13, the children's solicitor and the guardian went to visit them to ascertain their wishes and feelings, and indeed to look at the potential for separate representation. The girls were very clear that they did not approve of that plan. They wished to return to their father's care. They understood their father to be well now, and therefore they couldn't understand why they couldn't go home to live with their father. They were not prepared to canvass or really consider any arrangement whereby they would be split from their younger brother Harry. The solicitor, Ms Linden, was then giving active consideration to the need potentially for separate representation. This was on the back of the local authority's full assessment that did not recommend the children having any unsupervised contact or any care from their father. Within a matter of days, there was this strange communication that seemed to take place with certain people and not other people, the outcome of which